Thank you, Mr. Chairman. Good afternoon. It is an honor to appear again before this subcommittee to offer testimony on EPA's regulations for power plants under Section 111 of the Clean Air Act. I am a partner, as you said, in the law firm of Hunton & Williams, and I have practiced environmental law for over 17 years. And for the past decade, my practice has focused almost exclusively on climate change. On August 3rd, EPA released 3 rules to limit carbon dioxide emissions from power plants. The most controversial rule regulates those emissions from existing power plants under Section 111D of the Clean Air Act. EPA also released a proposed federal plan to implement the existing power plant regulations, accompanied by 2 model trading rules, one for a mass-based cap-and-trade program and one for a rate-based cap-and-trade program. The 3rd rule regulates carbon dioxide emissions from new, modified, and reconstructed power plants under Section 111B of the Clean Air Act. All of these regulations will be published in tomorrow's Federal Register, and they all suffer from legal deficiencies that are certain to be subject to litigation. With regard to EPA's final rule for existing power plants under Section 111D, that rule continues to suffer from numerous legal deficiencies, including the 2 issues that I raised before this subcommittee in March. The first issue is whether EPA even has authority under Section 111D to issue the regulations for existing power plants in light of the fact that electric generating units are already regulated under Section 112 of the Clean Air Act, which addresses hazardous air pollutants. The second issue is whether EPA's final regulations for existing power plants can properly be considered to be a system of emission reduction under the Clean Air Act, even assuming EPA has authority to issue a Section 111D rule for electric generating units. The proposed federal plan seeks to implement the regulations for existing power plants in the form of a cap-and-trade program for states that do not submit acceptable state plans. The accompanying model trading rules seek to provide rules that states can adopt to be part of a cap-and-trade program. Because the underlying regulations are unlawful, the proposed federal plan and model trading rules also cannot be lawfully promulgated. With regard to the final regulations for new, modified, and reconstructed power plants, it should be noted that the emissions rate for these new plants is higher than the rates for existing power plants. This has never before been the case. The new source regulations also suffer from legal infirmities. For example, the final performance standard for new coal-fired power plants is capture and sequestration, or CCS, and requires that carbon dioxide be captured, compressed, and safely stored over the long term. CCS has not been adequately demonstrated. In the final rule, EPA improperly relies on projects that received funding under the Energy Policy Act of 2005 to find that CCS is adequately demonstrated, which violates that act. The only project that EPA cites that did not receive such funding is a small Canadian unit that does not provide adequate support for EPA's determination. In addition, the subcommittee should be aware that a legal prerequisite for regulation of existing sources under Section 111D is that there first must be regulation of the same new sources under Section 111B. This means that if the final regulations for new power plants are overturned by a court, the legal foundation for EPA's regulating existing power plants would disappear. All of these legal issues give rise to a great deal of uncertainty regarding all 3 rules and cast serious doubt over whether they will be able to survive review by the courts. Face a firm September 6, 2016 deadline for the submission of a state plan or an extension request, or they face the risk of the federal cap-and-trade program being imposed on them. Meanwhile, the owners of existing power plants have to begin preparing as though they are going to have to comply with the rule. These preparations take many years, and the owners of the power plants do not have the luxury of waiting to see whether these rules will survive legal review. Thank you again for the opportunity to testify today.